is going on.
Yes.
Now the next definition, a very important definition which we discuss is district. See section 2 subclause 4. District means, Mansi, please open district section 2(4). District means the local limits of the jurisdiction of a principal civil court of original jurisdiction, hereafter called district court, and includes the local limits of the ordinary original civil jurisdiction of High Court. So I mentioned to you, in the city of Mumbai, the Bombay High Court is a district court because we do not have a separate district court. Okay? The Bombay High Court, under the letters patent, clause 12, acts as a court of original jurisdiction where the suits are directly filed under the provisions of the CPC as well as the Bombay High Court rules. Now, elsewhere, Pune district, Pune, Thane, it is the principal district court. Understand that. That's the meaning of district court. Now, some of the, you will find some of the legislations has specifically used the word district court. Now, if you want to go for a probate or letters of administration, now you please, you know that section 264 of the Indian Succession Act. Mansi, is it possible to open for you? Section 264 of the Indian Succession Act. 264. It tells you the probate and letters of administration can be granted by the district judge. Kindly see that. Section 264. Got it? Section 264 in the under the Indian, there is a use of the word district judge. Section 264. Then when you find similar word is used under section, now there are certain suits like known as the commercial division suits. The Bombay High Court and district judges, they try suits under the commercial division of the Civil Courts Act 215, or also known as commercial litigation. Now you will be learning in the third year at a subject known as intellectual property laws, IPR, trademark, patent, copyright act. Now suits for infringement of a copyright or passing of action or claiming damages will exclusively lie in a district court, and in Mumbai city in the Bombay High Court, that is section 134 of the Trademark Act of 1999. If Mansi, if you can open section 134, I'll be grateful. There they use the word district court.
So 134 of which act?
Section 134 of the Trademark Act. Trademark Act 1999, for the sake of the students' benefit, because they have used this word specifically district court. Patent Act के अंदर section,
I have shared it.
Yeah, 134. You can see that here when you see that there is word district court. See subsection 2 के अंदर use किया, including a district court within the local limits. So you cannot go to City Civil Court Bombay or Small Causes Court or Civil Judge Junior Division for enforcement of your rights under the Trademark Act for infringement or passing of action. Sanjana, you have to go to the district court in the city of Bombay, Bombay High Court. Then similarly, under the Patents Acts of 1970, section 104, if you can open the Patents Act, I'll be grateful to you. Patents, where new inventions are found, section 104. Now similar word is your district court, you see that. Okay, and copyright may section 62A, Copyright Act may section 62. These are the examples. That they can be manifold, many of them. I will not be burdening you with too many acts here. You will learn slowly and gradually. So here specifically mentioned your suit can only lie before the district judges. Mean a principal district judge, that means in the city of Mumbai, you can only come before in the High Court exercising ordinary original civil jurisdiction. Then there are admiralty suits in Bombay High Court. You know, have you heard of admiralty suits? under the Maritime Act. Ship से अपने सामान भेजा America, London, Dubai को. The ship was submerged. They could not deliver. The ship can be arrested. You can file a suit when the ship comes. The Bombay, Calcutta, Madras, these 3 high court, they have got special jurisdiction called Admiralty jurisdiction. These suits are coming under the commercial category. They will be filed only in the city of Mumbai. The high courts of Bombay, Calcutta, Madras, they are also known as chartered high courts. क्या बोलते हैं उनको? Chartered high courts under the latest patent. So these are the various examples of a district court and where the decree holders are. Okay, but you cannot go to city civil court for filing this suit. Now, whereas in the Specific Relief Act, when you want to file a suit, see on section 34, which deals with declaration, section 36, 37, 38, which deals with perpetual injunction, mandatory injunction, or temporary injunction, you can go to civil court, means city civil court Bombay or small causes court in the high court, depending upon the valuation. The valuation you determine under the provisions of the Maharashtra Enforcement of Pecuniary Jurisdiction Act 1977. That you decided. So the Specific Relief Act does not say which court. That is ultimately a civil court. Similarly, the Indian Contract Act, when you claim damages under section 73, it's a civil court. It can be starting from the small causes court, city civil court, high court. 25,000 small cause court jaiye, up to 1 crore city civil court pe jaiye. Above 1 crore you come to the high court. Okay, in district area like Kalyan, Pune, district court, civil just senior division, junior division, depending upon the determination. Okay, that is next. Now this is one of the important decisions. Then we have a section 2 में foreign court के बारे में है decree that you can go through. I'm not going to waste my time reading all this. And foreign judgment also you can go through. Government pleader. I'm just taking out to the most important judgment. Judgment next. See there. Judgment debtor. Please see the judgment debtor. पहले वहाँ पे सीखे आपने section 2(3) में decree holder. Now see the judgment debtor. Section 210. Mansi, please take it 210. Subclause 10. Judgment debtor mean a person against whom decree has been passed or an order capable of execution has been made. So when you, as a plaintiff, you have filed a suit for specific performance of a contract against your builder who is not giving you a flat. So you are the plaintiff. You are a person who booked the flat from the builder in Andheri or Bandra, wherever area. Your builder is not giving to you. So what you do, you will file a suit for specific performance. Abhi rera aaya ek baat hai. You have a right to also go before, if there are disputed facts, the fraud is played, come before the civil court under the provisions of section 34 of this specifications of section 15 to 20. You go for specific performance of a contract. So under this, in a suit for specific performance, your prayers are, number one, that this honorable court be pleased to declare that the agreement between the plaintiff and defendant builder is subsisting and valid. So that is a declaration you are seeking under section 34 of the Specific Relief Act. Okay. Now specific performance का मांगेंगे आप section 15 से लेकर 20 के अंदर. That this honorable court be pleased to order and decree the defendant developer builder to specifically perform the part of the contract, namely to put the plaintiff into possession and execute the documents, title deed, register the same. So you become a decree holder, the builder will become a judgment debtor. A judgment debtor he is. The defendant will become a judgment debtor within the meaning of section 210 of the CPC. Now another important definition is section 210, legal representatives. Now there's a difference between heirs and legal representative. Now here see the definition. Legal representative mean a person who in law represent the estate of a deceased person and includes any person who intermeddles with the estate of a deceased and where a party sues or be sued in a representative character or a person on whom estate devolves on the death of a person or so and so. Now you learned under the provisions of the Indian Succession Act, there are heirs, the person, the deceased, the testator has executed a will in favor of his grandson, so he will be a beneficiary or administrator. A beneficiary has a right to apply for a probate through the administrator. If there is no administrator appointed, the beneficiary has to make, the court will grant it. Now, whereas in the case of a legal representative, letters of administration can be issued. Suppose a bank, your grandfather has taken a loan from the bank and not repaid it. He will say that you cannot take up the plea under the will, I have given the entire property. But the bank lien has to be discharged. So the bank can also apply to the court for letters of administration under the provisions of the Indian Succession Act, which fact you are fully aware of here. That is section 254, 232, 233 of the Indian Succession Act is very clear in the first year which you have gone through. So letters of administration can be applied by any Tom, Dick and Harry. So like this here, legal representative definition is very wide. It is not just confined to blood relation. It is confined to person any claiming. In the case of a tenancy, a joint tenant can say that here, I have become the legal representative of a tenant who died. In a joint tenancy concept is different from tenancy in common under the Transfer of Property Act. The English law says that here, a person holding joint tenancy A and B, after the death of A, B will become exclusively the tenant of the property, and A's heirs cannot claim unless the tenancy is common. Under the Bombay Rent Act or Maharashtra Rent Control Act, that deals with tenancy in common and not with the joint tenancy. The joint tenancy concept you will find also in the Transfer of Property Act, section 45, 46, 47. वो आपको देख लेंगे. So in such a scenario, a legal representation can be made. Now, when a plaintiff or defendant dies in the suit in the civil court, there is a provision under the CPC Order 22 Rule 4. The Bansi, please take it out. When the heirs can be brought, heirs and legal representative. Order 22 Rule 4 निकालिए, Order 22. Can you please take it out?
Sir, I've taken it out.
Yeah, Order 22. Yeah, procedure on the death of several defendants of the plaintiff here. So here, the heirs and legal representatives can be brought on record. So the heirs can be blood relation who are agnates and non-cognates, and by consanguinity, and also the representation, tenants, their children, grandfather, father, banks, institution from where the loans are taken, they can come on record. So the expression is very wide here, which you please note that. Now the next important definition is mean profit, section 212. Please come to CPC section 212. Okay, 212, see that here it says, mean profit or property means of those profits which the person in wrongful possession of such property actually received or might with ordinary diligence have received therefrom, together with interest of such profit, but shall not include profit due to improvement made by person in wrongful possession. Now, when do you claim mean profit in a suit? When the suit is for recovery of immovable property from a trespasser or a tenant, licensee, or a person in wrongful possession, you say that the possession and occupation of the premises by the defendant is wrongful because, number one, he is a rank trespasser. He should be ordered to be evicted. A trespass suit would lie under Article 65 of the Limitation Act. Within 12 years, you must file it. Prayer A will be number one, that this honorable court be pleased to order and decree the defendant trespasser to quit, vacate, hand over possession and hand over to the plaintiff. Prayer B will be that this honorable court be pleased to order and decree the defendant to pay mean profits for illegal occupation in the premises from the date of the occupation or from the date of the suit till he actually vacate the premises. Because in the plain you must make an averment, the defendant cannot be permitted to occupy free of charge my premises. He is bound and liable to pay the market mean profit, mean the actual compensation prevailing in the market. So that is the prayer you must ask for specifically. Under the CPC Bombay में amendment हुआ है कि order 15 order 15A CPC amendment. Mansi, if you have got, just please see that here, order 15A Mumbai amendment order 15A. In a suit between license or like
A, what is it? Order 15.
Order
What's
15 15 Roman
yes.
15 and A Bombay amendment, Mumbai amendment to CPC. It is there?
No, sir, not over here.
I did not there. Please, those of you having, whenever you buy a CPC, you buy the CPC which has been amended by the Maharashtra legislature, because you know that under the provisions of the Constitution 7th schedule, the concurrent list item, the list number 13, it is a subject which the Parliament as well as the state legislature can enact a change. Under section 121 of the CPC, High Court can amend the rules but not the section. Parliament and legislature can amend the sections of the CPC as well as the rules. Whereas the High Courts, Bombay, Calcutta, Madras, and all High Courts in India, they have a right under section 121, 122 to make rules. They modify rules, they can do that. High Court has powers. Only the rule. They cannot touch upon the section. So please, when you buy a CPC lena aap as amended by the state of Maharashtra. Okay, there is a section 15A which specifically deals with deposit of mean profit. In a suit filed by the landlord against tenant or a licensor or against a licensee under the Presidency Small Causes Court Act, Maharashtra Rent Control Act, tenant or a licensee or a paying guest cannot be permitted to stay free of charge. They are bound and liable to pay the market rent or mean profits. So that is the amount mean profit. So mean profit includes the actual price except the renovation done. Agar wo tile badli kiya hai, he has renovated, painting kiya hai, that amount you cannot claim. Okay? The market rate ke liye ready reckoner of Maharashtra is required to be seen. What exactly is the amount? That it tells you the ready reckoner. So the court will pass an order that normally this is a final order which is passed, but under the provisions of 15A CPC, during the pendency of the suit, the court has a right to pass interlocutory order directing the defendant to deposit the amount. Tenant ko bhi bol sakte hain. Tenancy has been determined by the landlord by giving a quit notice under section 106. Termination notice, you know that. Now termination notice asking the tenant to vacate the premises is not required now in the wake of the judgment of the Supreme Court. Anyone knows the judgment? Please tell me. First year, second year student. Danpal Chettiar versus Yashoda Mai Ammal's case. Okay. 1976 Supreme Court, 1745. Please go and see, check this one. Danpal Chettiar versus Yashoda Mai Ammal's case is a 9-bench judgment led by Justice Untwala, who held that termination notice is not required to be given to tenant for asking him to vacate the premises except for arrears of rent under the rent control legislation, which says that. That means 106 notice is required to be given. See, I'm grateful to Mansi who has taken out this judgment here. This clearly said that you don't have to give the notice now. So you can file a suit here. The moment you file a suit, termination, the notice, the tenancy stands terminated by the passing of a decree by the court. So during the pendency, you can take out an application. Apart from Order 15A, there is one more general section for deposit of money, Order 39, Rule 10. Mansi, please take out Order 39, Rule 10. Order 39, Rule 10, CPC. Yeah,
Yes,
there's a deposit of money. No, under this provision also the court can direct the party to deposit the money. So normally you can invoke the provisions of Order 15, Rule A, 15A CPC, Bombay Amendment, Order 39, Rule 10, read with Section 151, which are the inherent power of the court to pass a decree. Then there is one more section, supplemental powers of the court. Supplemental powers Mansi, can you see section 94? Please check out section 94.
Yes, sir. Taken out.
Yeah, supplemental proceeding के अंदर आप check करेंगे 94 के अंदर the 94 clause E can make such other interlocutory orders as may appear to the court to be just and convenient. See that the wide discretion, the wide powers are given to the court to pass appropriate orders. No litigant should feel unhappy that the court has no powers. The lawyer should know his tools. As a young lawyer, when you go to the court of law, be fully equipped with the provisions of CPC. When you are appearing before a civil court, along with you must know your Evidence Act thoroughly well and keep a bare act of the CPC and Evidence Act in your pocket or in a laptop you have got, keep on using it. Similarly, for CRPC also, it's not that you are practicing civil law, you should not know the CRPC and other provision. You should know it. As a lawyer, you should embrace all the laws here. Okay? Now that is the mean profit. Now the next definition I will cover now is that here, now they see the meaning of the expression order. Section 214. Order means a formal expression of a decision of a civil court which is not a decree. Kindly see the distinction between section 22 and 214. So here order can be interlocutory order. An order passing order of injunction under order 39 rule 1 and 2. Please Mansi, just kindly open order 39. Order 39 rule 1 and 2. Yeah, this is an order of injunction. This will come within the mischief of order 214. Then order of deposit, just now we spoke of order 39 rule 10. It is an order. So that order is not a decree, not a final order. They are known as interlocutory orders. Kya kehte hain? Interlocutory orders, orders which are passed during the pendency of a suit. Order appointing a court commissioner under order 26 rule 9 and order 39 rule 7. The court has, the order 26 rule 9 check karo aap. Order 26 rule 9 mein there is the appointment of a commissioner local inspection ke liye. Then similar power is given under order 39 rule 7 check kare. Order 39 rule 7, see that here, detention, preservation, inspection. So these are more wide powers. So these are all called interlocutory orders. Okay, these are, that will come within the meaning of section 214 ke andar. Then 15 I won't trouble you, they are not very important. Okay, then every order, yes. Yeah, these are the important definitions which you must remember in the CPC. Okay, now having learned this section, now come back to determine the jurisdiction of the court, section 9. Please open section 9, Mansi, please.
Open, sir.
Section 9, thank you so much. See, the court to try all, civil suits unless barred. See the jurisdiction of the court and res judicata. Jurisdiction means competency to entertain a suit. Power to try a suit is called jurisdiction. And res judicata is a different issue. We'll deal with later on. This is dealt under section 11. Okay, I am now first concentrating on jurisdiction of the court now. Now it says, the court shall, subject to provisions contained herein, have jurisdiction to try all suits of a civil nature, excepting suits of which their cognizance is expressly barred, impliedly, barred expressly or impliedly. Now all suits of civil natures come before a civil court unless they are expressly or impliedly barred. Now what are the civil suits which are expressly barred? I gave you illustration. Under section 33 of the Maharashtra Rent Control Act, it says that all suits between landlord and tenant shall be exclusively tried by the Court of Small Causes Court. So, High Court and City Civil Court, civil courts are barred. You cannot come in the Bombay City. Now, section 91 of the Societies Act says that all disputes between member and society, cooperative society, touching the management and business of society, shall be filed in a cooperative court under section 91. It has exclusive jurisdiction. So there is express bar. So you cannot come to the small causes court, city civil court, high court for dispute. Okay. Now section 7 of the Family Court Act, check karo. Section 7. Section 7 of the Family Court Act says that all disputes, matrimonial dispute between husband and wife, relating to custody, relating to divorce, all matters, they go before exclusively to a family court now. Formerly they used to come to city civil court and high court. So they are now expressly barred. They go. These are some of the illustration which I am giving you. The illustrations are many, like the Indian Succession Act, which I give you that year. For probate, you have to go to district court. The Trademark Act may, intellectual properties may clearly say that for infringement of violation of a trademark, passing of action, copyright, somebody has stolen your story under the Copyright Act. All this, they go to the civil court and high court Bombay. So that is expressly barred or impliedly barred. Impliedly barred means there may not be express provision, but from the reading of the entire act, the court comes to the conclusion that this dispute cannot go to a civil court. It must be tried before the revenue court, like Maharashtra Land Revenue Court. पढ़ चुके होंगे आपने. And for determination, तुम्हारी land का number क्या है, हिस्सा क्या है, which zone में क्या है, what is this, and patta gitta, what is this? You cannot go to the civil court, high court for all this. So the Maharashtra Revenue Court, these are the collectors and the revenue courts are there. So by implication, you can determine that those courts are having that. So only when there is no express bar or implied bar, then the civil court come into play here. Now see the explanation 1. A suit, explanation 1 to section 9. A suit in which the right to property or to office contested is a suit of a civil nature. Notwithstanding, such a suit may depend entirely upon the decision of the religious rites or ceremonies. Now, right to property. Now, under the Specific Relief Act, Section 5 and 7, padhenge aap. Section 5 of the Specific Relief Act says that here, for recovery of immovable property, the procedure laid down in the CPC will apply. Specific Relief Act, Section 5 nikaliye, Mansi. Section 5 clearly said recovery. The procedure to be followed is the procedure in the Code of Civil Procedure Code. Now, under the Transfer of Property Act, all properties we recover, we go to civil court. Now, under Order 34, suit for mortgages, we go to the civil court. Okay, under the provisions of the Easement Act, we go to the civil court, the city civil court or the high court, depending upon district court valuation. Now, even it says that here, a property or an office is contested. Office is contested means a person may say that I am the manager of a temple or a Waqf board ke liye, I am the Waqif of a particular board. Such disputes also go to civil court unless barred under the special legislation. Now, according to me, a suit with regard to office now come in Bombay City, come under the Bombay Public Trust Act. With the Bombay Public Trust Act, you go before the Charity Commissioner. Under the provisions of Charity Commissioner, Charity Commissioner has the right to pass orders. A suit would lie under Section 50 and 51 with the permission of the Charity Commissioner, which you will learn gradually. Okay. Then there are suits with relating to religious or ceremonies. So they also come under the Bombay Public Trust Act. In case of a private trust act, no, certain properties may be private trust. Your father has created a family trust. So that doesn't come under the Public Trust Act. So there's a Private Trust Act. Under the Private Trust Act, jurisdiction is granted to the district judges, namely in the city of Mumbai, the Bombay High Court. I mean, as to who should be the trustee, as to who should be the beneficiary. These are the provisions before the court here. Now see explanation 2 say that for the purpose of this section, it is immaterial whether or not any fees attached to the office refer to explanation, whether or not office is attached to the premises of particular. So all the suits with regard to claiming position, a trustee of a temple or manager of a temple or a church or a mosque, they used to go before the civil court earlier. Now they stand barred by virtue of the specific relationship. When there is no specific legislation barring, you can come to the civil court for appointment for a mandatory order of injunction. There is no barrier. So this is how you discover the jurisdiction. A civil court has jurisdiction. Now, once the civil court you are discovered, these are the suits which are filed before the civil court. Now, the next topic, don't go for section 10. Now, you will have to go. Now, civil court determine kiya apne. Next step is now come to order 4 rule 1. Come to first section 26. I will come. Section 26 mein aaiye. Institution of a suit. Institution of a suit 26 mein. How a civil suit is filed? The presentation of a document called plain, the affidavit. Section 26 and order 4 निकालिए. Order 4 rule 1. The language of section 26 and order 4 rule 1. Suit to be commenced by plain. Got it? Every suit shall be instituted by the presenting of a plain in duplicate to the court or such officer appointed thereof. Plain shall be comply with the rules of order 6 or 7 possible. Plain shall be deemed to be duly instituted something. So here the civil law is set into motion by presentation of a document called plain supported by affidavit. Order section 26 and order 4 rule 1. Please note that. Like your criminal law is set into motion by lodging a FIR under 154 CRPC or a private complaint under section 190 and 200 CRPC. But here the civil suit is filed in the civil court by invoking the provisions of section 26 and order 4 rule 1 by the presentation of a document called plain. Now, what is a plain? What are the requirements? Please come to order 7. Please come to order 7. Order 7 is very substantial and very exhaustive, and you please, all of you, go and read it at home. I will just only briefly give certain. Now, yeah, because the short time allotted to me will not be able to cover here. Okay. Now, the first requirements are that here the name, the number 1, plain shall contain the following particular. Number 1, name of the court in which the suit is brought. So when you mention the name of the court, agar high court mein file kar rahe, in the high court of judicature at Bombay, bracket mein rahega, in its ordinary original civil jurisdiction. ये पूरा नाम रहा. क्या नाम रहा? In the Bombay High Court, bracket में OOCJ, ordinary original civil jurisdiction, ये नाम आ गया. City civil court रहेगा तो in the Bombay City Civil Court at Bombay. Small causes court in the Bombay City Small Cause Court Bombay, the name of the court आ गया. Next is the name of the court in which would be brought. The name of the description, place, resident of the plaintiff. The plaintiff is an individual. You have to mention plaintiff is aged so and so, residing at so and so place, and occupying so and so competent file. If it's a partnership company or a company, you have to mention plaintiff is a registered company under the Companies Act, having registered office at so and so place. Or defendant, a plaintiff is a partnership firm, whose partners are so and so XYZ. And that is how you have to give description of the parties. Then the name and description, place of the resident of the defendant also to be given. So both the parties, defendant ka bhi description they disclose karenge aap. Then number D, where the plaintiff defendant is a minor or a person of unsound mind, statement to the made to the effect. Now, as you know that minor plaintiff himself cannot sue, but the suit can be filed on his behalf by a gentleman called next friend, that is dealt under the provisions of order 32. Check kare aap zara. Just please open your order 32, Mansi, please, if you don't mind.
Sir, last 3 minutes are remain.
How many minutes, madam?
3 minutes, sir.
3 minutes only. I will
Yeah.
cover this. So when you see the provisions of order 32 of the Code of Civil Procedure that deals with the procedure, suit by against minors and person of unsound mind. Now, under this here, the suit can be filed by the minor through a person called next friend, and if he is a defendant against a guardian ad litem. Plaintiff may mention karega pro person. The present suit is being filed on behalf of the plaintiff minor, and no interest is being claimed by the person. I am the uncle or mama or so and so neighbor friend. I do not have any adverse interest. Means the plaintiff does not have adverse interest. So Mr. A acting through so and so as the next friend. If he is the defendant, he has to say that the defendant does not have any adverse interest and acting in a ad litem capacity. Then the next is here, see here, minor ho gaya, E ho gaya, facts continuing creating cause of action when it arose. Cause of action means the bundle of facts. When you are filing a suit against the builder, you have to mention when the agreement of sale was executed, when the builder has committed breaches, when he promised to give you the possession, when he has not given. So these are the facts which must be incorporated. The agreement of sale subsisting valid, and you have discharged your obligation, you have made the payment, builder has failed to give you possession, and hence the present suit is being filed for specific performance of a contract and for restoration of possession to me. That is called cause of action. If there is no cause of action, your claim can be rejected under Order 7, Rule 11 CPC, which we read now. That order becomes a decree within the meaning of Section 2 of the CPC, which we read right now. So I don't think we have further time, and we'll cover it here later on. Madam, time hai kya aur hamare paas?
No, sir, just less than